Okay, this is part two of chapter 12. We are on page 311 of the study guide. Well, actually 310 of the study guide with the Drug Free Workplace Act and Omnibus, and then the drug testing and stuff like that. Now, if you look on page 310, these are all, everything that up until 310 is federal. And then on page 311 and 312, a little bit, no, 311 is going to be state. But these next two areas of law, you need to know federal and state, but more importantly, they go hand in hand, which is why we skipped OSHA. So if we go back in the study guide on page 308 of the study guide, you have OSHA, Occupational Safety and Health Act of 1970. OSHA is a federal administrative agency dealing with workplace safety, is economy-wide, executive, or dependent because it ends with an administration in the name. Okay? Now, things that you need to know. This is what I call for OSHA the rule of 7,000. We had the rule of 12 for the Family Medical Leave Act. Now we have the rule of 7,000 for OSHA. In OSHA, penalties associated to OSHA situations are going to be $7,000 per violation or per day or per violation per day, whatever. So it's 7,000. Okay. So we'll get to that in a little while. But let's talk about what it covers. One, it wants to cover anything that requires workplace safety to be free from hazards that are likely to cause injury and/or death or serious bodily injury, and employers must abide by the standards associated to OSHA. Now, there's administrative warrants. Now, if OSHA has an administrative warrant to come on site and inspect, okay, the employer has the option in certain areas, especially when they don't have a warrant, to refuse. When you refuse OSHA to come on your property to inspect, they're just going to go and get a warrant and then come back and be even more nitpicky. So what Swin probably said in his videos was, an employer has the right to refuse in certain situations, but if you do, you're just going to have more in penalties associated to your actions because they're going to be more nitpicky. So he probably said the best situation for you to do is to not refuse. Just go ahead and let them on, because you're just going to get a more stiffer, more harsher penalty on the employer if OSHA has to come back and get a warrant, come back with a warrant that they didn't already have. So most employers would be wise not to question a warrant and allow it to go out. Why? Once again, the rule 7,000 when we get to all the penalties in a little while. All right. An inspection can be done randomly at any time when workers report violations to OSHA itself, or the employer self-reports a violation after an accident or an accident occurs. So basically random when a worker reports a violation, or when an employer self-reports a violation or an accident. These are all times that OSHA can come on and inspect. So basically they can come on at any point, any time. When an accident has occurred, whether the report is filed by the worker or the employer themselves, or randomly, okay? And the inspector will explain what they are trying to do, what they're trying to find, and the procedures they'll be used. And then they will report the violations to the employer. The penalties associated to these violations are going to be under what I say the rule 7,000. Any non-serious or serious violation is up to $7,000 per violation. Now, this is the high point, but still 7,000. A repeat is 70,000, or 7,000 times 10 for repeat. Failure to correct a violation, $7,000 per day until the violation is corrected. So if you get a violation on, say, a Tuesday, that's up to $7,000 for that violation. And if you don't get it corrected till Friday, it's another Wednesday, Thursday, another 7,000 each day. So 14,000 more for those 2 days. If you make a false statement on OSHA records, that's another $7,000. And then it can be unlimited for death benefits and criminal violations and stuff like that as well, for multi-million-dollar fines. Now, the thing associated on page 309 deals with common violations. Hard hats not being worn at the construction site, electrical problems, failure to wear a safety harness when required, failure to having protection from fires and stuff like that. Now, usually as a storyline, when chapter 12 is much more important, storyline about hard hats. So we're going to go with the federal equivalent right now, OSHA. OSHA would require hard hats to be worn at construction sites at various places, but construction sites being the big one. So if you're given a storyline on the exam about a construction site, the federal one is OSHA. State would be workman's compensation, but federal one is OSHA. And at federal level, you could have $7,000 fines per day per violation, all that stuff, up to $7,000 per day per violation with the Rule 7000. Okay? But then skip over to page 311 of your study guide. On page 311 of your study guide, it talks about workman's compensation under state level. Now we're going to talk about OSHA at the federal level and what the states can do at the state level, in addition to what OSHA can do at the federal level. And workman's compensation began in 1911 in Wisconsin, okay? I'm not sure if you need to know this state more than the other ones, like you maybe needed to know Texas, Wyoming, Kansas, you know, and then you got the Montana, Colorado, New York, North Dakota, and stuff like that for this test, but you need to know certain states. Wisconsin was the workman's compensation. It's basically state mandated insurance, and it covers the employee regardless of fault. As long as they intentionally don't injure themselves, it covers the employee regardless of fault. It can include death benefits, partial disability, permanent disability, total disability, permanent partial disability, all that stuff, okay? It's going to include. And all the employee has to show is proof that they sustained this personal injury, and it could be mental, but it's probably going to be physical, resulted from an accident or an occupational disease that arose out of the course of their employment. Now, if, for instance, you're working and you get your finger cut off, that would be covered under OSHA, potential violations federally, but under state, that would be under workman's compensation law. And the state mandated insurance or mandatory insurance covers the employee regardless of fault. So even if the employee was at a fault and when his finger got severed, he would still be able to get partial disability, total disability, or whatever, permanent, partial, and all that stuff. Each body part is worth certain amounts. The most important digit would be your thumb on your dominant hand. I'm right-handed, so my thumb on my right hand would be the most important digit. That's been an easy answer to easy question to give. When it says that certain things get injured in your hand, the most important digit is your thumb of your dominant hand, by the way. Okay? Now, it doesn't apply if I was to say, you know what, I know that the dominant hand in my thumb is the most important. I've learned to be able to do without my thumb, so I just cut it off intentionally to get workman's comp. That is not covered. It covers the employee regardless of fault, unless, of course, they intentionally do it, then it's not covered. Okay. Was it work-related? Did it occur during the employment? Were you at work? It can include mental problems as well. And it includes medical costs associated to your injury, temporary payments while you're on disability, that could be up to 2/3 of your normal salary, death benefits, partial and total permanent disability, and remember your thumb being the most important digit on the exam as well. So, questions regarding workman's compensation. If you're in your job description or working on your job and you get injured, so say you're out in the field, you're required to be out in the field certain times during the day, and you get in a car accident. Car accident was not your fault, regardless of fault, the car accident was, but it wasn't your fault. You're going to be able to get benefits associated to workman's compensation. So if you get injured, your neck's injured, whiplash or something like that, you can get benefits associated to state mandatory insurance under workman's compensation. If you file a workman's compensation claim, remember you cannot be fired for that under state court or state public policy exceptions under the rules that we talked about earlier. So if you file a workman's compensation claim, you're going to be able to get that workman's compensation as long as it's, you know, all the criteria apply to you, but you can't be fired for filing that workman's comp. So say I say, I'll pay you $10,000 for your injury. Well, you know your medical expenses and your future, you know, pain, suffering, all that stuff is worth much more than $10,000. So you want to go and file workman's comp. And I say, I'll fire you to file workman's comp. One, because it'll be reported to OSHA and I might have fines as well, depending on what happened at the federal level, but the state level, I don't want you to have to go through the insurance. If you refuse to, I say you do and you're fired and I fire you, when you do file workman's comp, you're protected under that state court, state public policy exception. Okay? Now, what if on day one of working, you don't wear a hard hat in a construction zone? That's a violation of OSHA, $7,000 fine if I get busted for it as the employer. But I can have you, what happens? I tell you to put on the hard hat. The next day, I find you not wearing the hard hat. The next day, I find you not wearing the hard hat. The next day, you get injured not wearing the hard hat. Are you able to file and recover damages under workman's comp? Yes, because regardless of fault. Now, could I fire you for filing the workman's compensation claim? No, because you have state court public policy exceptions, or you'd be protected there if I did fire you. But could I fire you for insubordination for not wearing the hard hat? Absolutely. But I can't fire you for filing the workman's compensation claim. So could I have fired you the day before because you kept not wearing a hard hat? Absolutely. Can I fire you for not wearing the hard hat? Absolutely. Can you still get workman's compensation benefits? Yes. You get them basically while at work on a work-related project. Like if you have to go on site somewhere, you're going to be covered to and from going on site, but you're typically not going to be covered going to and from work unless you adjust for a work-related activity. So if your boss says, hey, when you come into work, can you go by and get this? So you're picking up a part at some mechanic shop or something like that. If you deviate your normal routine to do that and get in an accident, then you're going to be covered under workman's comp. If you are just going to and from work, you're generally not covered. The only other option would be in a hazardous work zone, you may be covered under that policy as well. All right. That is going to be workman's compensation. Then the next thing we have is drug safety. And if you go back in the study guide, once again, to page 310 of the study guide, you have two acts at the very bottom of page 310, the Drug-Free Workplace Act and the Omnibus Transportation Employees Testing Act. Now, the Drug-Free Workplace Act says it applies to all companies that have at least $25,000 worth of business with the federal government. Now, that threshold is likely to move up based upon some lawmaking, but right now, $25,000 worth of business with the federal government. It basically says that you must have a written statement that says the use of possession of drugs, illegal drugs in the workplace is forbidden. Warn the punishment if violated. Establish a drug-free awareness program and enforce it. The employee must notify the employer of any drug convictions they have in the past. So all these things are under the Drug-Free Workplace Act. If you have $25,000 or more worth of business with the federal government, you must distribute written statements that say drugs in the workplace are forbidden. Punishment of what is going to happen if you're found with drugs. You must have a drug-free awareness program, and the employee must notify the employer of any previous drug convictions. That last one has been a test question. They'll say which of the following is not a part of the Omnibus Act, or which of the following is not a part of that one. Employee must notify employer of a previous drug conviction is under the Drug-Free Workplace Act. Now, the Omnibus Transportation Employee Testing Act, and I haven't heard the acronym for this, the Omnibus Act applies to certain federal employees. Now, it does not apply to all federal employees, just certain ones, and it doesn't apply to state or private businesses. However, most states adopt drug testing policies based upon omnibus and drug-free, mainly omnibus. So drug-free and omnibus are federal, but states mimic these in their state drug testing as well. Okay? So omnibus applies only to certain federal employees, drug agents, or federal public transportation, commercial motor vehicles, and stuff like that. You can test for the use of alcohol and drugs pre-employment, randomly during drug tests during the course of their employment, and after an accident. So if I want to get a job and it requires me to take a drug test before I get the job, that would be pre-employment. Omnibus would allow that for certain federal jobs, and state and private employers at the state level could do it because they mimic omnibus. But omnibus would only apply to the federal employees that are falling under this. Randomly during the course of your work, they can ask you for a drug test. And then if you have an accident, they can ask for a drug test for alcohol and drugs after that accident immediately. So say I take a job, and I take a job with a local school district, and the school district requires mandatory drug testing. I would probably have to take a drug test before I was able to be employed. If I pass that, and then I can be randomly tested during the course of the school year. If I refuse, I could be in trouble and lose my job and stuff like that. If I have an accident, say I drive the bus and I have a bus accident. I can be tested for alcohol and drugs under the state equivalent of omnibus. Okay? Omnibus, basically, the state drug testing mainly varies from state to state, but will mimic omnibus and also will mimic some of the Drug-Free Workplace Act stuff as well. Okay? So if an employer asks you to drug test, they can give you an actual test before you get the job, pre-employment, during the job itself, a random drug test, and then after an accident occurs. If you are not a drug testing company and you decide to drug test your company, you must give them time to get clean and pure, so to speak. So if you're going to start up a drug testing policy and now you're going to have random drug testing after the fact, you can't do it and say, okay, we're testing it right now. You've got to get them time to get it out of your system because they were under the assumption there was no drug testing when they took the job originally. All right, that is now pages 310, 311 with the federal versus state. I would note that. Remember, if you have an accident, okay, you can go under OSHA for violations, okay, because it's got to be reported to them. The workers can report it to OSHA. The employer can report it to OSHA. You can have fines up to $7,000 per day per violation. If you want, you can go for mandatory insurance. It's available under workman's compensation. Some digits are worth more than others. You're getting this on not to and from work unless you deviate for the work itself, but while you're in the course of employment, and that means you do field work while you're in the field would apply as well. Okay. Note that for a hard hat safety harness type situation for an exam question as well. If you file workman's compensation, you are protected under that state public policy exception. If you decide you want to sue for negligence, you can sue for negligence, or you can sue for workman's comp, either one, but you can only sue for both. You can get more for negligence, but you have to prove a lot more. It's a little more harder, whereas workman's comp is already state mandatory insurance. It's already there. And unless you intentionally did it to harm yourself intentionally, you're going to be protected regardless of fault. So why not go for the workman's compensation, even if it is a little less? All right. The next thing we have is on page 312 of your study guide, and it deals with a couple of acts. And that is the Equal Pay Act of 1963, the first act, and the Civil Rights Act of 1964, also known as Title VII. These are the two bigger acts from the federal discrimination area. Remember, we talked about employment at will doctrine can be modified contractually. State courts, state public policy, state statutory law, state legislatures can do it. And we went over all those exceptions. I said there's a fourth exception, and that would be federal discrimination law. Now, under federal discrimination law, basically starts on page 312. The other ones are more federal employment law, but not discrimination law. These are discrimination law aspects. Okay, so this will be that fourth one under the employment at will modifications. All right. The first act that we're dealing with is the Equal Pay Act, EPA, Equal Pay Act of 1963. It only deals with pay and gender. It does not deal with hiring, firing, promotions per se, because a promotion may include wages, but it does deal with pay. If you're getting paid more or less, and gender, male, female. We don't care about anything else. Under the Equal Pay Act of 1963, administered by the EEOC, Equal Opportunity Employment Commission. The EEOC, an administrative agency created in 1972. That would be a economy-wide federal administrative agency. It's independent commission, economy-wide because it goes over all types of employment. The EEOC is in charge of the Equal Pay Act and says men and women doing substantially equal work should be paid the same. Now, there are many exceptions to this rule. The first exception is if it's not gender-based, if it's white versus black, if it's race, color, if it's a national origin, if it's religious-based. None of those apply to the Equal Pay Act. It's only men and women. In 1963, only men and women. They should be paid the same for substantially equal work. Now, the case statistically is not the case. I mean, it's still about 75, 80% a woman gets of what a man typically gets. But there are the exceptions. The first exception, once again, is if it's race, color, national origin, religion, those don't apply. We'll get to those a little bit later on, but those don't apply under the Equal Pay Act. It must be gender. The other one is seniority. If you've been there longer, you can get paid more. So if Bill has been there for 10 months and Jane has been there for 2 months, and Bill gets paid more for doing the exact same work, that is fine because Bill has seniority over Jane. If Jane has been there for 10 months and Bill's only been there for 2 months and Bill gets more than Jane, then we have a problem. But if you're going to pay someone different, and you can pay them the same, that's fine. But if you're going to pay someone different, and it's a man versus a woman, you must have a justification for doing so. One of those is seniority. So if the man has been there longer, then that is okay. So if you get paid $11 an hour because you've been there longer, and the other person's getting only $7.25 an hour because they just started working there, and they're doing the same job, that's fine. Seniority. The other one is merit-based pay. This could be based upon quantity of work done, the quality of your production, the hours that you work, the number of hours you work. So say Bill and Jane are both antitrust lawyers for the company. They've both been there 3 years. They both have the same degree. They should be basically paid the same. If Bill been there longer or Jane been there longer, they could probably get paid more. That would be seniority based. But if they've been there the same time, they've had both same qualifications, everything, they should be paid the same. But what if Bill does 250 hours a week of billable hours, whereas Jane only does 200? Then now Bill has done more production level over the time period. Therefore, Bill can get paid more based upon merit-based. Under Equal Pay Act, Bill would be able to be paid more. Jane, even though she's done the same job and been there the same time period, doesn't give as much work product. Now, the work product could be widgets. Say Bill does 100 widgets per hour. Jane does 80 widgets per hour. Then Bill could get paid more because he does more widgets per hour. Even if they've been there the same time period, same amount of time, that's fine. Okay? Now, what if you're wanting to do it where it gives you a storyline that Jane does 100 widgets at 80% non-defective rate. So basically 80 widgets per hour. Bill does 140 widgets, okay, but he only does it at 60%. If the numbers are roughly equal, then yeah, they're doing the same basic level. But if you're doing more quantity or better products, then yes, you can get paid the same. And if it's based upon national origin, race, color, religion, and stuff like that, it's not gender-based. So if we're given a storyline, and he says a black man is paid more, a black man is paid less than a white man, this would be an Equal Pay Act violation. That is incorrect. If a black woman is paid more than a less than a white woman, that's based upon race, color, doesn't count. If a woman is paid less than a man for the same work being done, same level of time at the company, same level of production, then we possibly have a violation of the Equal Pay Act of 1963. Now, the other thing you need to know about the Equal Pay Act of 1963 is it's the same job for same pay. But what if it is a different job and you want to be paid differently? There's a term called the comparable worth theory, and it was found and under the idea of the Equal Pay Act of 1963 dealing with gender. Comparable worth theory says different jobs that are valued the same by society should be paid the same for society. So say wait staff, predominantly female, is just as valuable to society as driving a car, taxi cab work, predominantly male dominated. If they are valued the same, comparable worth theory says they should be paid the same. Well, the problem is, who's going to value wait staff, who's going to value this, and who's going to come up with the value of each of them? Someone would have to do it and then show the discrepancy. These are different jobs, and therefore they can get paid differently. Whether one's dominated by male, female, doesn't matter. It's the same job should be paid the same. This is a different job, not valued the same. Different job, valued the same, equals same pay is comparable worth theory's idea. Comparable worth theory is not adopted in the United States because very simply, it's not the same job. If it's not the same job, it shouldn't be paid the same necessarily. Therefore, the Equal Pay Act doesn't apply. So if Jane has a different job than Bill, but Bill gets paid more, well, that's fine. It's a different job. If it is the same job, then we better have either merit-based, i.e. been there longer, I mean, merit-based, you're doing better work or more work is being done, or seniority, you've been there long. If not, then we have a problem. But if it's going to be based upon, if it's going to be based upon different types of jobs, then it doesn't fall into there because comparable work is not adopted in the United States. It's not a part of the Equal Pay Act, and that is a multiple choice question. Different jobs, forget the value, are different jobs, therefore don't fall under the Equal Pay Act. All right, the next one is Title VII. And Title VII is probably one of your big four on this exam. Title VII is going to be one of the ones that you're going to have a few storylines or just general questions over. And then also fines and jail times under environmental law. You have a bunch of little ones that are going to be important. Okay, so the Civil Rights Act of 1964, a year later after Equal Pay Act came in, now we have the Civil Rights Act of 1964, also known for test purposes as Title VII. Okay, Title VII is also under the EEOC as well. Now, one of the things that you need to note is what is the primary differences between the Equal Pay Act and the Civil Rights Act of 64 for test purposes? One, the Civil Rights Act of 64 encompasses more areas than just gender. It has race, color, which are pretty much the same thing for storylines, national origin, religion, and gender. So it has 5 protected classes in Title VII: race, color, national origin, religion, and gender. Okay? Whereas Equal Pay Act only does gender. All right? Civil Rights Act of 64, i.e. Title VII, applies to virtually all areas of employment: hiring, firing, promotions, grievances, wages, all that stuff applies. Whereas the Equal Pay Act only dealt with pay, not hiring, firing, and all that stuff. Only deals with pay. Okay? So race, color, sex, national origin, and religion. They are both enforced by the EEOC. EEOC enforces Title VII and the Equal Pay Act, whereas the Department of Labor Wage and Hour Division, we talked about that earlier, does not only the Family Medical Leave Act, I don't know if I talked about that earlier, but the Fair Labor Standards Act, and also another one we're going to talk about, Rehabilitation Act of 73. All right. In order for civil rights Title VII to apply, you must have 15 or more employees. Texas, we have the Texas Workforce Commission, that's the state equivalent of Title VII. All right, 15 or more employees. So if a company only has 8 employees, Title VII doesn't apply to them. If it has between 15 and say 49, Title VII applies, but the Family Medical Leave Act doesn't apply. If it has 50 or more, Title VII and Family Medical Leave Act both apply, just to give you a heads up. And when we're talking about Title VII, we're talking about any discrimination in terms of hiring, firing, promotions, grievances, wages, anything based upon all areas of employment based upon race, color, religion, national origin, or gender. Not just gender, and pay, dealing with Equal Pay Act. All right? Now, there are 2 types of discrimination under Title VII. All right, Title VII, there's disparate or differential treatment, and then there's disparate or adverse impact. They both use disparate, but he likes to use differential treatment, also known as disparate treatment, and disparate impact, also known as adverse impact. And if you look in your study guide or your packet that I gave you, the red packet, number 8 is Title VII. I'm not going to go in detail on this, but there is a little chart that we put together. Hold on, let me get there is a little thing on the difference between differential treatment and adverse impact. Both are called disparate. I would go differential treatment versus adverse impact. When we talk about this, we're talking about you cannot treat people differently based upon religion, sex, national origin, race, color, all that stuff. But disparate treatment or differential treatment is different from adverse or disparate impact. One is much more intentional, the other one is unintentional. The first one, disparate treatment or differential treatment, is intentional, where you intentionally discriminate against someone in that 5 protected classes. If I discriminate because you're a woman, if I discriminate because you're black, if I discriminate because you're a foreigner, national origin, if I discriminate based upon you being Catholic or not Catholic, that would be direct intentional discrimination of one of those 5 protected classes. So if I put a sign in the window that says no Irish need apply, that would be intentional discrimination against national origin. Therefore, that would be a Title VII violation, differential treatment or disparate treatment. Okay? Because I intended to discriminate. The employee, in order to do a differential treatment case, the employer must show that they are a member of the protected workforce, one of those 5 protected classes. They must prove their prima facie elements of the case. They must, if it's for applying for a job or trying to get a job, they must show that they're at least qualified. They applied within the proper framework. They must do all those things. Then they must show that they're a member of a protected class that was injured by this. Then the employer must show and articulate a non-discriminatory reason for rejection. It must be non-discriminatory, it must be unintentional. Then the potential employee or employee must show that I lied as an employer. And therefore, you must prove I intended to discriminate. Okay? If I put a sign that says no Irish need apply, and you take a picture of that, you say, no, I didn't ever do that or say that, and they show you the proof, then I intended to discriminate, correct? So therefore, that would be a differential treatment, disparate treatment type case. If it is unintentional, but has an indirect impact upon a protected class, then that would be an adverse or disparate impact case. Once again, the potential employee has to show that they were qualified for the job, applied for the job, all that stuff, that they're a member of one of the 5 protected classes, race, color, national origin, religion, or gender, and show that one of the protected classes is indirectly discriminated against based upon a job qualification. So say I say that in order to apply for the job, you must be at least 6 foot or greater or taller. Well, that would take out most, if not all, of the women that apply for the job within the workforce. It wouldn't take out as many men, it would take out almost all the women. In fact, when I do these live sessions, usually only one girl is able to raise her hand out of all the girls in the group. So out of 20 or so employees that are there, only one could possibly get that job at being 6 foot plus. So it has an adverse or indirect discriminatory impact. Tall people or 6 foot plus is not a direct discrimination. It's not, there's tall people is not a protected class under Title VII, but it has an indirect, an apparently neutral job qualification. 6 foot plus has an indirect discriminatory impact. So an apparently neutral job qualification indirectly discriminate against a protected class. Therefore, unless I can show that the job qualification equals the job itself, I need to find a better, less restrictive means. And that is the adverse or disparate impact. Let me give you an example. If I say you must be at least 6 foot plus because you got to reach to a bin, okay? But what if you could get like a step stool? Yes, it may be a little more difficult for you to, get the step stool and go up and then get it, but easily could do it. Or someone with long arms could reach the bottom bins and only have to get them to the top bins. And even those to get to the top bins would have to get on a stool if they're 6 foot plus anyway. Well, then I'm only discriminating against people for those smaller bins. So why not just say, okay, you need to be able to reach to that level and or have the capability through mechanical device, i.e. a step stool, to reach that level. Then I'm not discriminating against anybody, okay? So for instance, if you've ever worked at A&M, they give you these yearly tests that you have to go over, and one is in a disparate or adverse impact case. And it's talking about, having a height requirement to drive a bus on campus. We don't have, all you have to do to drive a bus is be able to reach the pedal and be able to see over the steering wheel. You don't have to be 6 foot to do that. You can be 5'5" to do that. So therefore, your job qualification should be able to perfectly drive the bus. I hit the pedal and be able to see over the steering wheel in an easy manner. You don't have to be 6 foot plus. Now, if the job qualification does equal the job itself, then it's okay. But if it doesn't, and you can have a less restrictive means, we need to do that under disparate or adverse impact case. So if you're given a case or a question on the exam, and he says, you're directly discriminated against because you're a woman, or you're directly discriminated against because you're a black male, you're directly discriminated because you're non-Catholic, or something like that, that would go towards differential or disparate treatment. If it's indirect, like you must have a high school diploma, that would affect people of race, color in certain urban areas. If it's just for a job as a janitor, you don't need a high school diploma for a janitor's job. Okay, so therefore the job qualification of a high school diploma doesn't necessarily equal the job itself, has an indirect discriminatory impact upon race, color. And this is especially one of the cases of Griggs test versus Duke Power Company. And the Griggs test, which is on page 313 of your study guide, are the tests associated to figuring out whether adverse or disparate impact has occurred. All right. Now, when it comes to sex discrimination, sexual harassment falls under Title VII. Title VII includes sexual harassment because it deals with the idea of discriminating against a male versus a female in terms of their gender based upon sexual harassment. Okay. Now, there's two types of sexual harassment. Quid pro quo is where if you do something for me, I will give you the job, or if you don't have sex with me, you're fired. If you sleep with me, you get the promotion. If you sleep with me, you get a raise. All those things would be quid pro quo sexual harassment. They fall under Title VII because sexual harassment falls under Title VII. That would be illegal. Hostile working environment is the other example of sexual harassment. That would be where you place someone with an unwelcome atmosphere within the job description. If I was to come to work as your boss every day telling blonde jokes and you're blonde, you may get offended after a while if I say blonde jokes. Like, what do I say? What if I come in on Monday and say, what's the difference between a blonde and a screen door? When you bang a screen door, it doesn't follow you around for a week. And everybody's laughing, joking, you're kind of miserable. On Tuesday, I go, what do a blonde and a screen door have in common? The more you bang them, the looser it get. And all of a sudden, you're like disgusted by all this stuff. That would be a hostile working environment. Also falls under sexual harassment, also would be a Title VII violation as well. Now, what does not fall under Title VII? Pregnancy also falls under Title VII as well, although Pregnancy Act of 1978 also details it, but it falls under Title VII. So the difference between a man and a female when it comes to sexual harassment and or pregnancy falls under Title VII. But sexual orientation does not fall under Title VII. Title VII and the EOC does not care about homosexuality, transsexuality, bisexuality, any of that stuff. Gender neutral, any of that stuff. It does not apply to that. Now, Clinton has its own executive orders dealing with sexual orientation, and an executive order says it's illegal, but not under Title VII. So what is covered under Title VII when it comes to male versus female? Obviously, hiring, firing, promotions, wages need to be the same for the same job, doing the same work, okay? All those things, because Title VII deals with all areas of employment. And it also deals with sexual harassment. It also deals with pregnancy issues, but it does not deal with sexual orientation. So if we're talking about Linda, who is gay, versus Linda, who is straight, Title VII has nothing to do with that. Linda is a female. That's all we care about in terms of Title VII. Now, for Clinton's executive order, you would care whether Clinton, if Linda is fired because Linda is a lesbian or Linda is bisexual. That would fall under Clinton's executive order, but would not fall under Title VII. Now, Title VII does not mandate affirmative action. Affirmative action is not mandated by Title VII at all. Title VII has nothing to do with affirmative action at all. Even though race, color is a part of the 5 protected classes, Title VII doesn't deal with affirmative action. Affirmative action is under Executive Order 11246. Executive Order 11246 deals with race affirmative action, race, color affirmative action under LBJ's Executive Order 11246, which just basically says that in order to get a government contract, government subsidy, in order to do anything with the government, you must have an affirmative action program in place. Now, that affirmative action program can be obviously tweaked and stuff like that, but you must have one in place, and these are legal, but they are not mandated by Title VII, which is a multiple choice answer. You need to note that's not correct, but it is under Executive Order 11246 by LBJ. Now, affirmative action, this is not in your book. It's not in your study guide. It's usually discussed in class. It's still in class every other semester at least. It's on the exam, and people that only come to tutoring know it. So listen to this. There's a thing called the Rehabilitation Act of 1973. And the Rehabilitation Act of 1973 is number 11 in that red packet, the list of all the acts. The Rehabilitation Act of 73 is not in your book. If SWIM doesn't cover it, you need to know this real quick. It was created for Vietnam veterans coming back from the Vietnam War, and it established curb cuts and handicap ramps and signs near building entrances. Now, those are all a part of the Americans with Disabilities Act, ADA, that we're going to talk about briefly in a little while, okay? But it also established an affirmative action program for those with disabilities. Now that affirmative action program is under the ADA, Americans with Disabilities Act, but the Rehabilitation Act of 73 also created affirmative action programs for the disabled. So if it gives you a question that says affirmative action programs were created, Executive Order 11246 for LBJ is one of the answers, but also the Rehabilitation Act is 73. And now under the ADA, Americans with Disabilities Act. But if it gives you one just dealing with race, then yes, you need to go with affirmative Executive Order 11246 with LBJ. But understand, affirmative action has two different areas: Rehabilitation Act of 73, now under the ADA, and Executive Order 11246. All right. Religious discrimination. On page 313 of your study guide, actually on page 314 of your study guide, you have the EOC versus Samboza, Georgia. I doubt you're going to have this case name on the exam, but the storyline: the restaurant didn't have to hire someone because their religious practices did not allow them to trim their facial hair. Samboza, Georgia wanted to have a clean cut image, and facial hair was not allowed, and they did not want that as a part of their image. The person whose religious practices didn't allow them to be hired sued. Now, the EOC probably would have been best suited to say this is a religious discrimination in regards to the law. You're discriminating against someone based upon their protected classes. In the hiring, firing, workplace aspect of it, this should have been a Title VII violation. But EOC found in favor of the restaurant, saying that because of sanitary issues, we wanted to have this situation in place where you could have a clean-cut image. Now, it goes against the Title VII guidelines a bit, but somebody like a ZZ Top person couldn't get a job under this situation because of the EOC. I would note that for a test question. I think there might be one in the back of the study guide dealing with that. If not, there is a question associated to number 3 at the very top of page 314. Now, we just did race discrimination with affirmative action, so I've already done that. So now we've got ADA and ADEA. These are the last two things we have under Chapter 12 that we need to go over. ADA and ADEA. ADEA is Age Discrimination Employment Act. The Age Discrimination Employment Act makes it a protected group age 40 and older, and there are a bunch of different exceptions. State law may protect those under 40, but the federal equivalent, ADEA acronym, is the one that protects those 40 or older, okay? Now, in this situation, the old professor said you had to have 20 or more employees. And that's where it became interesting, because on my exam, I remember we have one version that would have 17 employees, one would have 7 employees, one would have 28 employees. And if you had 28 employees, Title VII and ADEA applied. If you had 17 employees, Title VII applied, but ADEA didn't. If you had 7 employees, neither one of them applied. So it's kind of like Form A, Form B, Form C for SWIM. Now, SWIM doesn't really talk about the number of employees. It's not in the book, so just note that it is 20, but anyway, note that for the test as well. Now, one of the questions that's easy on the exam that people miss more often than not because they don't do it, he'll say, under Title VII, what age is protected? And it gives you 30 and older, 35 and older, 40 and older, 45 and older, and he'll go through all a bunch of different numbers and then none of the above. And people just pick 40 and older and move on to the next question. Title VII has nothing to do with age. Age Discrimination Employment Act does, but Title VII doesn't. Title VII, race, color, national origin, religion, gender, nothing to do with age. So that question is missed frequently. And in fact, I think it's one of my questions. I think it's question number 1 in the pretest that we didn't go over, going over that material. People miss that question more often than not. ADEA deals with it. Now, the ADA, Americans with Disabilities Act of 1990, also applies with 15 or more employees. The EEOC is in charge of this as well. And if a worker is qualified, even with a disability, then they cannot use that disability as long as they can do the job. They're qualified with that disability and they have reasonable accommodations can be done. You cannot use that disability against them in the hiring, firing, promotions, all that stuff. Reasonable accommodations must be provided by the employer. Now, what is reasonable is going to be the test question. If you are on the 5th floor of a building that doesn't have any ramps, doesn't have an elevator, then hiring someone that is an employee that is in a wheelchair may not be reasonable to you, a company that's small. Now, if you're a Walmart, then yes, you have the funds to be able to create a ramp and or create an elevator or get into a building that could be done, because then that would be a reasonable accommodation to you. Once again, Americans with Disabilities Act is a qualified worker regardless of disability. You still got to be qualified to do the job. So if I'm in a wheelchair, but I can do the job because say it's computer related, then that my disability being in a wheelchair should not have any effect on it. However, if it's a job that I cannot do because I'm in a wheelchair, then I'm not qualified to do the job. But if I'm qualified and reasonable accommodation can be made, then I must be eligible for promotions, hiring, firing, all that stuff under the ADA with 15 or more employees, and that's ADA, no E in there. ADA, no ADEA, ADA in this situation. Okay, so storylines it didn't give you because we've already done the Santa Fe case. That was that male, the white and black employees getting fired. I talked about that for taking stuff and discrimination, reverse discrimination that was applied. Okay, so say you have someone who is bisexual, say someone who's a woman, say someone's in a wheelchair, say someone who is Asian, say someone who is black. So you have one person that's white, say someone who is black, bisexual, handicapped, female, and from a different country. You have all different things that could apply to that given situation. Would the Equal Pay Act apply? Yes, when it comes to everything but the handicap. When it comes to the gender base, yes. Would it include the black versus white, bisexual versus heterosexual? It wouldn't apply to any of that stuff. But Equal Pay Act would apply to the gender aspect of it. Title VII would apply to all the other ones. ADA, Americans with Disabilities Act, would apply to the wheelchair thing. Clinton's executive order would apply to the sexual preferences. So you have a bunch of different things. Race, affirmative action program could apply under Executive Order 11246 when it comes to white versus black. So you have a bunch of different things that could come into play. That's why Title VII is so important for test purposes on different test questions as well. All right, we've gone over all these different areas right here. I don't think you need to know Clinton's Executive Order number 14. The actual name is no Clinton's Executive Order. You need to make sure you filled in the Employment Act for the different ages under Fair Labor Standards Act. And then you have the terms and concepts that we went over. Workman's comp and drug testing is on that other page. We went over that in the study guide as well. All right. For the very end of this, I'm now going to go over some of the questions that are good in the back of the study guide starting on page 321 of your study guide. I'm going to do that. And then I'm going to figure out what I'm going to do with the discrimination quiz on the last page of the packet. Either we're going to have a Q&A on Zoom overall, and then we can do this quiz, but these answers are not in the study guide, or not in the answer key. So if you want to check these, because there's multiple answers that can apply, sometimes 3 or 4 answers to each one. If you want those, I can email them to you, or I can screenshot and send you a picture of it, of the key, or we can do it in a Zoom meeting as well. On the ones that are the most important questions, I would do D, E, and F. D, E, and F if you're going to do any of them before any of the others, okay? Now, in the back of the study guide on page 321, some good questions that you have. Number 1, okay? Number 3 is that one about the Rehabilitation Act that if he didn't go over in class, it's not in the book, and it's not in the study guide. So number 3 is one that you need to note as well, okay? Number 5 is a good one. Number 8, with little Johnny now being 14, whereas in question number 1, little Johnny was 15, okay? Number 12 is a good one with comparable work. Number 13 would be a good one because of Civil Rights Act and what works and what doesn't work. Number 17 is pretty easy with the thumb. And then number 19 is a pretty good one as well. Okay, I don't think any of these are really great questions on the exam other than number 1, number 8 as storylines, number 5 is a storyline, number 12 I've heard being on the exam just done a little bit differently. Number 13 is a storyline question as well, scenario also. So those would be the better ones of those. All right. If you have any questions on chapter 12, feel free to email me. Feel free to text me. You have my number on the back or on the front of the packet if you need to text me. I'm going to do chapter 14 hopefully today, tonight, and put both of these on the videos on. That'll be for the ones that are common. And then my goal is to maybe do Zoom for the chapters that are different, and also to talk about grades going into the final exam as well. All right. If you have any questions, once again, email me, but this is the end of chapter 12 itself.